We have seen the express trust and trust. Trust is defined in section 3 of the trust ordinance, and express trust also defined as amended by 2018 Act. Now here we will see the separate topic or the relevant topic to the express trust. Section 6 of the trust ordinance. The section 6 of the trust ordinance provides, subject to the provisions of section 5 and 107. Subject to the provisions of section 5. What is section 5? Section 5 consisting of 3 subsections. Subsection 1 talks about the creation of trust or validity of the trust in relation to the immovable property. Subsection 2 talks about validation of trust in relation to the movable property. Subsection 3, something different that we will see. First of all, we will see what is subsection 1 and 2. No trust in relation to the immovable property shall be valid unless declared by last will or non-testament document in writing signed by author of the trust. Blah blah, it goes on. Go to the subsection 2, no trust in relation to the movable property is valid unless it is in writing signed by author of the trust. Then it is immaterial whether it is in relation to the movable property or immovable property, that should be in writing. Then come to the subsection 3. Subsection 3 provides those sections, that means the provisions of subsection 1 and subsection 2 do not apply where those 2 sections effectuate a fraud. That we have seen in the express trust. The example also we have seen. Now simply we can say, by using subsection 1 and 2, any person who tries to commit a fraud, then subsection 3 will come forward to help the person. Because in subsection 3 is something exception to 5.1 and 5.2. Now here we are going to see certainty. That's a section now. Certainty of relate certain matters. Subject to the provisions of subsection 5 and 107, that's a de facto trust. In the absence of evidence of the formalities in relation to the creation of trust, the court has the power to declare there's a trust. That is 107, that's de facto trust. That also limited to only charitable, not anything else. If it is a private trust, court has no power to declare that. If it is a charitable under 107, forget about all these 5.1 and 5.2, court has the power to declare it. Then the trust is created by words. That's a very important. In 5.1 and 5.2, we have seen that it should be in writing. Those 2 sections emphasize it should be in writing. But here, trust is created by words or acts. Words in the sense, the words that spoken, or the words whatever it is in writing. The acts in the sense, it does not include writing. That's whatever acts. When the author of the trust indicates the following matters with a reasonable certainty. What are the matters? First, intention of the author of the trust. To create the trust He must have the intention that should be certain. The purpose or object of the trust should be certain. Then the beneficiary, to whom the trustee is going to pay the beneficial interest. That is another interesting part. The beneficiaries must be certain or must be clear. The trust property, that's a very important part. If the trust property is not there, then it's not clear or not certain, then there is no trust at all. Another condition, the trust property should be transferred to trustee, unless there are two circumstances. First thing, trust is declared by last will. Why is that? Last will comes into operation on the date of death of such person. Then you can transfer the property now. Then what we should do? Then there must be a testamentary action in terms of civil procedure code. Then the court will declare that that specific property is subject to trust. That's one thing. Author of the trust is himself to be a trustee. That the author of the trust is one and only trustee, then no need to transfer the property, because earlier it was his ownership, sole ownership. Now he is a trustee of the trust property. But if there's a board of trustees, that means consisting of so many people, in that case we must see. Then we must go to the vesting order under section 112 of the trust ordinance. The board of trustees asks the trustee to transfer the property to board of trustees. Otherwise, you can go to the court and get a vesting order. All these matters, the certainty, the reasonable certainty of the matters specified in section 6, arose very long time ago in the case of Knight versus Knight. There were 3 certainties. Now we broke into 4 subsections. Now, really speaking, earlier it was in 3 certainties. That's why 3 certainties. It's known as 3 certainties. First of all, the words employed could be deemed to be imperative. The language used must be very clear enough to show the intention of the author of the trust. Second one is subject matter to be very clear, must be very clear. This is a subject matter, this is a property. Then the object or the person, that's the thing. Here in our trust ordinance, in section 6, purpose or object separately and beneficiary separately. But in the Knight versus Knight, more than 200 years ago, decided by English court, the object or persons intended to be benefited must be certain. When you talk about the property must be certain, there must be reasonable certainty in relation to the trust property. Keep it in your mind, the property must be segregated. Now suppose there are 2 million rupees, but 1 million declared as trust, 1 million rupees declared as trust. Then the 1 million should be withdrawn from that account and deposit in a different account, separate account. You can't mix the trust property with another property. That's why the property always must be indicated with reasonable certainty, and also it should be segregated. Now what we have seen in section 5, it should be in writing, but section 6 refers act. The trust may be created by act also. Section 5.1 and 5.2 say very clearly provide that it should be in writing. But 5.3 ignore. 5.3 ignores the section 5.1 and 5.2 and say that if it leads to the fraud, then you can declare the trust. Or you can ask for trust. as we have seen in the example. Simply I would like to tell you, under A and B, under phi 1 and phi 2, A transfer the property to B. Under mutual understanding, it should be returned to A. Then A must pay the money whatever received plus interest. In that case, now B argues that no, the transfer is outright transfer. Now what is happening here? He commits a fraud. In that case, and also B may argue, if the intention to create the trust, the A should have done under section 5.1 or 5.2, but he didn't do that. Therefore, there was no intention to create the trust. This is outright transfer. He may argue, in that case, A get the help of 5.3 and say that this is it leads to the fraud, then you can't. Section 5.1 and 5.2 do not apply, because B now commits or try to commit a fraud. Now these are the section 5. Now we will see one by one. Intention to create a trust. Author of the trust must have some sort of intention to create the trust. In construing a term of deed of trust, the question is not what they had intention, what the intention they had at the time of execution of trust. Then what? What's the meaning of words that they have employed in the document? That's very important. We don't worry about what they have, what the intention they have. Now we will see what are the words that they have employed. We will interpret those words and identify the intention, whether he has or he had intention to create the trust. The use or non-use of word trust in a document is not indication of intention. Casually somebody can use the word trust. I trust you. That's meaning is there's some sort of confidence. Casually you can use it. But sometimes you can use with the intention to create the trust also. Therefore, whether you are using the word trust or not, doesn't matter. And also you can't take that something there's an indication to the intention, even though the word trust used in the document. Some author of the trust, sometimes they can use some precatory words or recommendatory words, sometimes expressing some belief. He will do that. I am hoping that he will do that. That's an illustration given to section 6. Desires. I desire. I hoping. I have confidence. Those are the words. Sometimes precatory words, recommendatory words, or expressing some sort of belief. It amounts to the trust, because when you interpret those words, it indicates the intention to create the trust. But keep in your mind, there is no formal words to create the trust. Then what we should do? How to identify the intention? There is only one way: to interpret the words that they have spoken, or the word that they have used or employed in the document. By interpreting those words, we will see whether the certain person or the author of the trust had some sort of intention to create the trust. Now we will see some cases, the decided case laws. In the case of Visalachipilla versus Sivahamiammal, there's a gift, the property gifted to somebody, but donor retained the power to sell the property. If the donor dies, then donee should pay 500 rupees to the person named as S. When you see these facts of this case, the plaintiff argued that it seems that almost the illustration of section 6 in the trust ordinance, But the defendant argued, this is nothing the gift at all. This is nothing gift at all. This is nothing trust at all. This is a gift. Under Roman Dutch law, this is a gift subject to certain conditions. No trust at all. Then really speaking, the court must see the document. The court saw the document and interpret the words. First of all, we must see two words there. Absolutely forever. The property, when he gifted the property, the first point, within inverted commas we can say, absolutely forever. That's given to him. In some other place. Out of the said land and premises. Out of the land and premises. Then something like beneficial interest. Indication of some sort of beneficial interest. Then going on. Another inverted commas. Performed and satisfied out of the property. That's it. Performed and satisfied out of the property. This is something like beneficial interest. Something indication of the intention to create a trust. Then the court held that this is a trust, not that gift. Then thereafter, in the case of Arubhagam Pillai versus Velu Pillai, that was a more or less deed or gift given to another person. But the first, again inverted comma, that's very important point. That's the way we must interpret what the word they have used. Take rent and profits. The first thing. You take the rent and profits. The second thing, perform puja plus festival in the temple stand thereof. After lifetime of such person, that the eldest son should do that. No right to sell the property at all or transfer the property at all. The court discussed and see the whole situation here and held that there is no trust because that's a condition. Property transferred, but there are two conditions. You must perform puja and you must do some festival. That's all. It should go on. But there are conditions, you can't sell it. But this is something very narrow interpretation. But earlier case, the Vishalachipala case, that's a wider interpretation given. Then we will see some other English case. Paul versus Constant. That's another interesting case. Husband left the wife and associated with another mistress. Then after in the employment he got lump sum money. Then he decided to deposit in his name plus in mistress' name. They went to the bank and asked to deposit the money. Then the bank advised them, because you are not husband and wife, better to deposit in one name. Then both agreed and deposit in husband name. At the time of deposit, at the time of opening an account there, the man said, not the husband, is a man said, the money is as much yours as mine. The money is as much yours as mine. This is the word that's words he spoken there at the time of opening account. By interpreting these words, the court held that there's a trust. Then this is a way we must identify the intention, that the word that they have employed in the document or the words that they have spoken at the time of execution, whatever it is, we must identify. Then we will move on, the object and the beneficiary. Object is clear. It should be clear. as we have seen in the charitable trust. If it is charity, the intention to create charity, but we don't know which charity, maybe education, maybe relief of poverty, whatever, then we can give effect to that because it is for charity. But we don't know whether it is charity or not, then it is void. The object must be set. Then come to the beneficiary. Beneficiary must be identifiable. Then second thing is, the amount of interest to be paid shall be ascertainable. We must know how much of money we are going to give it to beneficiary A, beneficiary B. That we must know. That should be certain. First of all, we must know who is beneficiary, ABC. Then the issue is in the case of Anthony Gaspar versus Bishop of Jaffna. Trust property was the land adjacent to the seashore with the shade built. The people in the fisheries community get together and collected some money and gave the money to the bishop. And the bishop built a shade in the seashore. Really speaking, there is a beach. Then it is for the benefit of these fisheries community, but not limited to the present members. Even future member, unborn child may come and do the business there, or stay here, or do whatever. Then this is for the fisheries community. Then the fisheries community, for the purpose of certainty of beneficiary, is it possible to identify the beneficiary? The court said that, without referring any section, court said that community of persons can be a author, can be a owner of the property. Then community of persons can be beneficiary. That's the way the court decided. Another case, Kandasamy versus Kumarasekaran. In this case, Anthony Gaspar case was distinguished. The issue is here how to identify the beneficiary in an unincorporated body of persons. If it is an incorporated body, any body of persons may be incorporated by Act of Parliament or under the provisions of Companies Act, whatever, that can be done. If it is a incorporated body, there's a register, then you can see these are the number of members. But unincorporated body of persons, we don't know. Today maybe 10 members, tomorrow 15, another day after tomorrow about 5 members. It fluctuates all the time. We don't know. There is no register. Then, in addition to that, if it is incorporated body of person, that is recognized and getting some sort of legal person status. Legal person. If it is an incorporated body. But if it is unincorporated body, there is no legal personality. If the sale of immovable property cannot pass the title to the unincorporated body of persons, therefore the court said that because there is no clear matter in relation to the beneficiaries, we don't know who are the beneficiaries in an unincorporated body of persons. Therefore, there is no trust. But in the English case, we must say Lacey versus AG. In that case, the gift to the unincorporated body. If the gift to the unincorporated body, then we must say that prima facie gift to the individual members who are members on the day itself. Suppose today there's a gift given to unincorporated body that is for the members registered, or today the members who are there in the association. Then it can be validated such a way But here in Sri Lanka, it said that no, you can't do it because the beneficiaries are not certain. Then we will go to the subject matter, certainty of the reasonable certainty of subject matter. First of all, the trust property must be capable of disposition. And also the property must be transferable to the beneficiary. But in certain cases, it depends on the deed of trust. Sometimes it may be transferred to the author of the trust, sometimes it may be transferred to the beneficiary, whatever it is. But trust property should be a trust property from another trust. That's why Section 8 provides subsisting trust. If there's a trust of, say, suppose there's a 1 million deposit in a trust for the trust, that's a trust money, then there's an interest about, say, suppose 2,000 rupees, you can't create a trust for these 2,000 rupees because it is already trust of the trust. That cannot be done. That's another case, English case we will see here. Clove Milk versus Martin. Now we have seen the trust property. When you talk about the properties, that should be segregated. Should be segregated. Now in this one, in the Martin case, what happened? The manufacturer of yarn supplies the yarn to the cloth manufacturer. This is happening for a long time. The manufacturer of yarn giving the raw material to the cloth manufacturer. Manufacturer is producing clothes. After some time, the manufacturer of yarn decided, oh, this is something not good, because if anything happened to the factory or the manufacturer of cloth, what about our property? They're worrying about their property. That's a general thing. Then what happened? They asked to retain the title until the yarn converted into clothes. Even after clothes produced, they must have the title on that clothes. It was agreed, but the problem, after some time, the manufacturer of clothes collapsed. Then the issue was here whether the trust property is certain. It should be, first of all, identifiable, and second thing, whether it is segregated from others. Now, first of all, now cloth is there. Where is yarn? You can't identify. You can't see that because it is in the cloth, converted into. Like clay and pot. Once the pot produced, there is no clay at all. You can't identify, you can't see the clay. Likewise, here also cloth is there, but no yarn at all. First thing is, trust property is not identifiable. Second thing is, it is not segregated from cloth. Can't be done. Then court said that the trust property is not certain, therefore there is no trust. Likewise, another case we will say, English case, Sprange versus Bernard. In this case, wife transfer the property to husband. Transfer the property to husband absolutely. And said that, that's very important, the remaining part of what is left should be kept for the benefit of another person. Then where is the trust property? The remaining part, what is left, that we don't know. Then the trust property is not clear. Court said that there is no trust because trust property is not certain. Then finally, we will see, in the absence of certainties of the matters that we have specified in section 6, the intention. If the absence of certainty in relation to the intention to create the trust, there is no trust at all. The purpose is not clear, no trust at all, but we have seen the charitable matter that we have seen subject to that. The beneficiaries is not certain. Beneficiaries are not ascertainable or identifiable. Then what is the situation? Then By operation of law under constructive trust chapter 9 of the trust ordinance, trust is arising under section 85 of the trust ordinance. Then finally, trust property, there is simple way. If there is no clear, if there is no certain about trust property, then there is no trust at all. Then what we have seen today, this is something matters relating to creation of trust should be certain. As we are simply say that intention should be clear. Intention in the sense, intention to create the trust. And the purpose should be clear. And beneficiaries, there are two things what we have seen. Beneficiaries, who are the beneficiaries, and how much of amount we are going to give to the benefit, that also much, and the trust property. These are the matters we must see. And also I would like to say you all, if you are unable to understand anything, or if you want to clarify anything, or any doubts or whatever, you can use the comment. By using comment, you can ask any clarification that will be given. Thank you for